Welcome to Lowndes Legal Talk, where we share perspectives on legal and business issues affecting you.
Hello, I'm Drew Sorrell. I'm a partner at Lowndes, and with me is Melody Lynch, who is my law partner also at Lowndes. We're here today to talk about House Bill 969, which was proposed in the Florida legislature in 2021 and is very likely to pass. And the Governor DeSantis, has indicated his support and that he will sign it if passed. So with that, let's talk about actually what this bill is, Melody.
House Bill 969 is the privacy bill that covers certain for-profit businesses if you meet one of three thresholds. The first threshold is that you have global revenues exceeding $25 million, or you have 50,000 or more consumers, households, or devices that are reached by your particular business, or 50% or more of your revenues are derived from selling or sharing information about consumers. And companies that fall into any one of those three buckets are going to be impacted by this new legislation if it ultimately passes. I think it's important, Drew, to talk about who it doesn't cover, because a lot of our clients won't be impacted by this legislation. For example, all nonprofit businesses are excluded, and any business that falls below those three thresholds that we just talked about won't be impacted by the new requirements to protect consumer personal information. Drew, when you're looking at the House bill, what does it require specifically for businesses to do?
Let me say this, the bill is 40 pages long, and I'm not going to walk through every single bit because I don't think our viewers want to actually hear that. But what I am going to talk about is, to answer your question, some of the highlights. What it basically does is sets up a law where you have to tell consumers via your website or another means exactly what you do or don't do with the data. So your privacy policy that is on your website now is mandatory, and it has to indicate that it was updated within the last year. So again, the point is you can't just put a privacy policy up that's been there forever and then ignore it. But then you take the privacy policy that you're required to update, and you have to specifically say the types of information that you're collecting, and then what you're going to do with it. Are you going to sell it, or are you not going to sell it? Are you going to use it for a marketing purpose, or are you going to use it for a processing purpose? Once you've set up the expectations of the consumer, that then has to be the mantra that you follow, if you will, when you're using that data at your company. What you can't do is say, I'm going to do one thing and then actually not do it. And what you can't do is say, I'm going to do it for one thing and then over a period of time, drift into a different category and then you're using it. Now, this is where it gets a little bit complicated. The law specifically says that you have the right to use the data in a manner that would be consistent with what you generally told the consumer. The question is, and that's going to be a problem for everyone, is how do you decide what is or is not consistent with that requirement? But that's in a nutshell what it does. So Melody, what do you think? What do you think of that? What do you think it means in plain English?
I think in plain English, Drew, it's going to cover personal information belonging to consumers that's being captured either at the point of sale or when the consumer interacts with a business. And one question that I think some of our viewers may have is, what is personal information, right? Is that just my name? Is it my name in combination with other things? And this bill does specifically delineate what's included in personal information. And that is your first name and last name, plus some information, or just your first initial and last name, and one of the following. So if your social security number is being captured, your driver's license or Florida ID, if you use that, a medical history, mental health history, or your health insurance number, or even your username and password, or in combination with a security question. Anything that would allow a business to be able to tap into your email would be covered as personal information. I also think in plain English, we talk about consumers, but what is a consumer for purposes of this bill? And the Florida legislature has told us that that's either a Florida resident or somebody who's here not on a temporary basis. So when we talk about the impact to some of our tourism industry and hospitality industry, it won't involve people who are just coming to our theme parks for a week vacation. They won't be included or be consumers for purposes of this legislation.
I was also going to say that with respect to consumers, that there's a question of what it means to be doing business in Florida. And that's a complicated question and a complicated answer. But basically what it means is you can be a business outside of Florida. And if you're purposely directing commerce to the state, then it could cover you. So hypothetically, if I'm sitting in Montana, but I'm running a store that sells things to Florida citizens, and I'm collecting money from them, and it doesn't require you necessarily to collect money, but this statute hypothetically is going to apply to you if you're directed, like you said, with the definition of Florida consumers. So it's an interesting set of coverages, if you will.
Yeah, I think that's a good point. I also think when we look at what those consumers can do, right? I mean, the bill is very explicit in terms of a consumer can ask your business no more than 2 times a year for a copy of the personal information that you've collected about them. So they can't ping you every week. You're not required to respond more than twice a year. But as the business, you do have to provide that information free of charge, and you have to give the consumer the ability to opt out, to correct their information, or to say, I want this specific piece. I want my social security number deleted, for example, and then the business has to comply.
And to that point, there's also some coverage for what I would call generically children. So if you're 16 or over, then you're able to have your information dealt with by this statute. If you're 15, 14, 13, then you have to opt in, meaning that the statute assumes that you have the ability to opt in, which is kind of interesting. And then if you're 12 or younger, then your parents have to opt in for you. And the bill literally says that's the opt-in clause. So you can't just assume that you have that ability to sell to them if you know that they're younger. Interestingly, too, the bill describes what we lawyers would refer to as willful blindness, meaning if you choose not to know on purpose the age of your consumers, then we assume that it does apply and that they're underage. So you can't just ignore it.
Yeah, and I think the underage aspect comes up when you look at penalties too, because there are triple damages if you're dealing with a consumer that's age 16 and younger. And, speaking of the penalties, they can be rather steep. If you violate their civil penalties, $2,500 for each unintentional violation and $7,500 if a court were to deem that your violation was intentional and that you had some notice and still, willfully or otherwise continued your practices of utilizing the information in an unsafe way. And there is a cure period. So I think that's good for clients to know too, because if your business is approached or you receive a demand letter, you have 30 days to fix whatever is broken about the way you're doing business. So you do have an opportunity to correct before there's any civil penalties imposed.
But to that point too, there's also the ability for a private consumer to bring a cause of action against the company for failing to comply. And the statutory penalties run between 100 and 750 per claimant, which kind of suggests that class actions may be a big problem for violation of this, because usually a business is not going to violate the rights of just one person. Their policies, if they're not quite right, would have the effect on multiple people, which brings us back to the class action vehicle. So it can be a big danger zone, if you will, for businesses that are covered by this act. So with that, and I guess we should add too that there's an attorney's fee provision, so that if you do get sued and the person that sues your business prevails, then not only do you have to pay the damages, but you'd also have to pay for the attorney's fees and costs arising from that. With that, Melody, I think probably we're close to wrapping up, but do you have any other final thoughts?
No, the only other thing I was going to mention is that in addition to the parade of horribles that you described in terms of the damages, there's also injunctive relief available. And I
Good point.
think there will certainly be some plaintiffs' lawyers who are looking to stop businesses from doing business. And so I think for all of our clients, really taking heed of this legislation, updating their privacy policies now, and making sure that they're reasonably protecting the data. Because if they're encrypting it or aggregating the data rather than maintaining it in individual form, then they're going to be protected and they won't face these steep penalties that other companies may find themselves embroiled in a extensive litigation over.
Right, and you actually mentioned something that I wanted to talk about just very briefly, and then we can close out. But this statute actually explicitly requires reasonable security to be applied to all of this data, and it applies a statutory retention schedule. So not only do businesses now have to statutorily pay attention to security with respect to the data, but they also have to have in place a retention policy that says, consistent with the statute, that they get rid of the data after the purpose for which it was collected was used or done. And then part two, if failing that, there's a catch-all that says, if you last had contact with the consumer a year or more ago, then you also have to delete the data. And so gone are the days where you can just keep data forever. The statute now requires that you not do that. Other than that, I don't have anything else. How about you, Melody?
No, I think that's all. I think we're here to answer additional questions that companies have as this goes through committee. We've seen it move pretty quickly through the legislature. And like you, Drew, I anticipate that it will be signed into law and that all of our clients will be looking at whether this applies to them and finding ways to make sure they're in compliance and, don't violate any of these new provisions, because there's definitely some heightened awareness that needs to go into privacy and making sure that all data is secure.
Agreed. And with that, I think we'll close and say goodbye.
Thank you for joining us for Lowndes Legal Talk. For more information about today's topic or to learn more about our attorneys and practices, please visit lowndes-law.com.